Hello, everyone. I'm Yazan Ibrahim, or as some of you might know me, yazan.abogosh. Today, we're going to dive into a fascinating and essential topic, Fraud Examiner's Section 2 Law Basic Principles of Evidence. Today's deep dive into the world of basic principles of evidence. Whether you're an aspiring fraud investigator, a business owner, or simply curious about how organizations manage their finances, or if you are auditor, this journey will shed light on the often complex systems that drive decision making. Evidence is the cornerstone of justice, the vehicle through which allegations evolve into legal truths or are dismissed as falsehoods. Think of it as the backbone of every courtroom drama, the instrument through which facts are proven or disproven before a decision is made. But what exactly is evidence, and how does it ensure that a fair and just conclusion is reached in legal disputes? Let's embark on this journey together to unravel the fascinating principles of evidence, exploring its intricate forms, applications, and unique rules across jurisdictions. At its simplest, evidence refers to anything, be it testimony, documents, tangible objects, or exhibits, that helps prove or disprove an alleged fact in court. Its purpose extends beyond the obvious clarification of facts. It provides a structured framework to ensure relevance, reliability, and fairness. Imagine being handed endless irrelevant details in a trial. Chaos would prevail. Evidence rules exist to prevent this, filtering out unreliable or prejudicial materials, creating an environment that fosters justice. Now, these rules aren't universal. They vary significantly between jurisdictions. Consider the United States, where the Federal Rules of Evidence, FRE, first enacted in 1975, govern federal courts, while individual states have their own sets of rules. Cross the border to Canada, and you encounter the Canada Evidence Act. Or dive into civil law systems, where formal evidentiary codes may not even exist. Judges instead weigh all relevant material without the procedural rigor inherent to common law systems. The diversity in rules highlights the importance of understanding the nuances of evidence in any specific legal system. Fraud examiners, for instance, must tread carefully, relying on legal counsel to navigate this complex terrain. Now let's delve deeper, starting with the three basic forms of evidence. First, there's testimonial evidence, the most familiar to us, involving statements made under oath by witnesses. Testimonial evidence itself divides into two categories: lay witness testimony and expert witness testimony. A lay witness speaks from personal experience, what they saw, heard, or directly experienced. For instance, a neighbor recalling the screech of tires in a sudden crash from their vantage point. Contrastingly, an expert witness, someone accredited through education, training, or experience, has the unique ability to provide opinions essential to a case. Think of a forensic scientist analyzing a crime scene, or an economist explaining market trends in fraud litigation. Next, there's real evidence, tangible objects tied directly to a case. Picture a blood-stained knife submitted in a murder trial, or a handwritten letter introduced to verify a contract. These objects speak louder than words, allowing the jury to physically connect with elements of the case. The last form is demonstrative evidence. While it's not part of the original event, it helps visualize and simplify facts for a jury. Items like charts, diagrams, or even computer-generated models fall into this category. It could be as simple as a map detailing a suspect's movements, or as intricate as a 3D model reconstructing a car accident. Unique care is required to ensure that these aids are accurate and not overly persuasive, for they are tools meant to clarify rather than to dominate. Once we have an understanding of these forms, we confront an age-old distinction in the world of evidence: direct versus circumstantial. Direct evidence plainly proves a fact without inferencing. Consider an eyewitness who testifies they saw the defendant holding a weapon. On the other hand, circumstantial evidence relies on inference. For instance, imagine the defendant's fingerprints found on the weapon hours after the alleged crime. In fraud cases, circumstantial evidence plays a pivotal role, as intent, so central in such cases, is rarely proven through direct means like confessions or admittances. Instead, patterns, behaviors, and secondary details pave the path to uncover the truth. But not all evidence, be it direct, circumstantial, testimonial, real, or demonstrative, will find its way before a jury. This is where admissibility comes into play, setting essential requirements for evidence to be considered. Relevance and authenticity take center stage here. Relevance ensures that only evidence contributing directly to the issues at hand can be considered. For example, prior unrelated crimes are typically inadmissible unless they are used to establish a specific factor like motive or intent. Authenticity, meanwhile, guarantees that the evidence presented is genuine and unaltered, reflecting exactly what it claims to represent. Admissibility also involves unique challenges. Evidence, while relevant, might still be excluded if deemed prejudicial, too confusing, or unnecessarily repetitive. For instance, a gruesome photograph from a crime scene might be excluded if it unfairly sways the jury's emotions. And jurisdictional variations further complicate things, particularly when it comes to the admissibility of illegally obtained evidence. In adversarial legal systems like those in the US or the UK, additional common law rules apply. Take the best evidence rule, which champions original documents over copies to avoid tampering, or the rule against hearsay, which bars out-of-court statements to prove a claim unless exceptions, like the spontaneous exclamation of a terrified witness, apply. These rules work together to safeguard fairness, ensuring that only trustworthy evidence informs decision-making. And what about the exhibits we often see dramatically unveiled in court? Exhibits must undergo rigorous authentication to establish their validity. For instance, a handwritten letter might require testimony from someone familiar with the author's handwriting, or a forensic expert who authenticates the ink and paper. Special attention is needed for high-risk categories like digital evidence. Unlike physical records, digital data, emails, phone records, social media posts is notoriously easy to modify. Thus, it often necessitates extra scrutiny, such as metadata analysis or corroborative testimony, to confirm its origin and integrity. Let's now turn to a particularly captivating category: self-authenticating evidence. Documents like official government records or certified business documents don't require a witness to establish their validity. They are presumed authentic. Photographs similarly grace a courtroom when they accurately depict facts relevant to the case. It's essential, however, to prove that they remain unaltered and their content is representative of the event in question. Finally, despite their varying natures, all forms of evidence, whether testimonial, real, or demonstrative, must pass foundational hurdles before they're admitted. Exhibits need to be marked for identification, often labeled as either plaintiff's exhibit or defendant's exhibit. At times, stipulations where opposing parties agree on facts can spare certain evidence from dispute, allowing it to be directly placed into the record. These small procedural details streamline trials, removing unnecessary hurdles and sharpening the case's focus. In conclusion, the principles of evidence weave a meticulous, fascinating foundation for justice itself. They ensure that only the most equipped facts and exhibits gain entrance into the courtroom, protecting fairness on a fine-edged balance of relevance, reliability, and impartiality. By understanding the forms, applications, and intricacies of evidence, we unravel a complex legal tapestry crafted to achieve truth in an imperfect, ever-evolving world. Legal proceedings often rest on the delicate balance between presenting compelling evidence and adhering to rules designed to ensure fairness and justice. But what happens when evidence, whether a document, statement, or testimony, meets those rules but sparks controversy due to how it's presented, its reliability, or its potential to mislead a jury? Here, we'll explore the fascinating and complex world of objections, the intricacies of admissible evidence, and the safeguards that underpin modern judicial systems. Let's start by understanding objections to exhibits. Even evidence that checks all the boxes for relevance and authenticity can be excluded if it violates procedural rules, such as those against hearsay or prejudice. For example, evidence that evokes an emotional reaction from a jury, rather than focusing on hard facts like a gruesome photo, might be deemed too prejudicial. The judge steps in to review these objections and has a few possible responses. The evidence can be admitted as is, altered in some way, or excluded entirely. Sometimes, determining admissibility requires separate, focused hearings. Fraud trials, in particular, can push the system to its limits because they often involve mountains of documentary evidence that must be carefully examined. And speaking of prejudice, that issue often arises again with character evidence. This type of evidence involves suggesting that someone's personality or tendencies, like their honesty or history of violence, make them more likely to behave a certain way in a specific situation. Sounds simple, right? Yet this evidence is largely inadmissible across many systems, including US courts, for a great reason. Human behavior is unpredictable. Basing judgments on someone's character rather than their actions invites bias and encourages juries to focus on who a person is rather than what they did. Exceptions do exist, though. For example, criminal defendants can present evidence of their good character in certain circumstances, but doing so opens the door for the prosecution to counter with evidence of bad character. Another key exception: previous acts or crimes may be introduced, but, and this is crucial, not to show that someone has a general propensity toward wrongdoing. Instead, they're used to highlight specific motives, patterns, or other critical contexts tied to the case. This fine line, outlined in laws like the Federal Rules of Evidence, FRE, Rule 404B, maintains fairness while ensuring relevant information isn't excluded outright. Fascinatingly, civil law courts, which typically don't involve juries, don't restrict character evidence as tightly, as professional judges are considered less susceptible to bias. Now let's pivot to opinion testimony, yet another area where courts tread carefully. Lay witnesses, for instance, are generally limited to sharing first-hand observations, things they've personally seen, heard, or experienced. They're not permitted to give opinions unless those opinions are rooted in their own perception and can assist the jury in understanding a factual point. However, even then, these opinions can't edge into legal territories reserved strictly for judges and juries. Take, for example, someone saying, "I think the defendant is guilty." The courts rule out such statements because determining guilt isn't within the witness's authority. In contrast, expert witnesses have far more leeway. These are individuals with specialized knowledge, whether in medicine, engineering, or another technical field, who use their expertise to provide professional opinions. But even experts face limits, particularly in criminal cases. They may analyze evidence or explain complex concepts, but they can't testify about a defendant's guilt or innocence. Why? Because their role is to inform the court, not to decide the outcome. When presenting any form of evidence, another hurdle often rears its head: the best evidence rule. This one's straightforward in theory. When trying to establish what a document says, the actual document, or a reliable copy, must be presented. This rule aims to prevent inaccuracies or alterations from skewing the truth. In fraud trials especially, certified copies of public records and original documents are crucial. And as the digital age evolves, courts have adapted the rule to account for electronic evidence, acknowledging its importance while requiring careful handling to ensure its authenticity. But even with authentic evidence, the issue of hearsay can arise. Under the rule against hearsay, statements made outside of court generally can't be used to prove a claim's truth. This rule exists to prioritize statements that can be cross-examined in court over those made informally or in highly subjective circumstances. However, as you might guess, exceptions abound. Courts will often allow hearsay if it falls into certain categories, like admissions by an opposing party or testimony offered under oath at prior legal proceedings. Similarly, trustworthy business or government records created as part of regular operations may also find their way into evidence under this exception. Some of the most compelling exceptions stem from the immediacy of certain statements. For instance, present sense impressions, statements made during or right after an event, are admitted because they are seen as spontaneous and reliable. A perfect illustration is a 911 call during a robbery, with the caller describing the events as they unfold. Closely related are excited utterances, which occur when someone makes a statement under the stress of a startling event. Given the high emotions at play, courts treat these as raw, unfiltered reactions less likely to be deliberate fabrications. You might also have heard of exceptions for statements about then existing conditions, be they mental, emotional, or physical. For instance, a declarant might say, "I feel sick and dizzy," and this could later explain a subsequent action like causing a car accident. Similarly, statements made for medical diagnoses form another exception. These include not only the patient's words, but sometimes even third-party accounts that provide crucial context, like a parent describing a child's symptoms to a doctor. For expert witnesses, learned treatises, reliable and widely accepted academic works can also play an invaluable role. These might seem like handy tools for a courtroom debate, but their use often comes with restrictions, like being referenced only during cross-examinations to challenge or support an expert's testimony. We also can't overlook the procedural backbone of handling evidence, the chain of custody. Put simply, this process ensures that any evidence, whether physical or digital, remains unaltered from the moment it's collected until it's presented in court. Each step, who handled the evidence, when and how, must be carefully documented. For example, if a letter is being used as evidence, protocols might require noting when and from whom it was received, alongside detailed storage practices to maintain its integrity. Even a minor break in this chain, such as a missing document log, risks undermining the evidence's credibility. However, courts often weigh any irregularities carefully, allowing a jury or judge to decide the evidence's ultimate significance. Beyond evidence itself, the courtroom also hosts battles over credibility, particularly through the process of impeachment. Here, the focus is on undermining the reliability of a witness by exposing potential biases, inconsistencies, or limitations in their testimony. For example, if a witness's prior statements contradict their present claims or their ability to perceive events reasonably is in doubt, their testimony can lose its impact. Even a witness's criminal record can come into play, but only under specific guidelines, such as instances involving dishonesty or recent felony convictions. Lastly, let's touch on privileges and protections, which exist to shield certain types of sensitive communication from disclosure in court. Think of attorney-client privilege, where a person's discussions with their lawyer remain confidential. This principle encourages openness while ensuring legal advisors can effectively represent their clients. Similarly, marital privileges keep spouses from being forced to testify against one another, reflecting society's interest in preserving the sanctity of certain relationships. Navigating the rules of evidence requires a deep understanding of both legal principles and the overarching need for fairness. From procedural safeguards to ensure the integrity of evidence to rules that protect individuals from unfair bias, these frameworks demonstrate how modern judiciary systems strive to maintain justice while grappling with the complexities of human behavior. The courtroom is not just a venue for truth, but a methodical arena where the mechanics of fairness are as important as the facts themselves. Thank you for watching, and as always, continue learning, stay curious, and we'll see you next video.